Good afternoon. I'm Jeff McConnell. I see some familiar faces and some that are less familiar. Thanks for having me. I really appreciate it. This is the second time I think I've visited with this group. It was a long while. We were in another part of the building. Even though we're kind of seated, I characterize it as somewhat of a formal setting. I don't think we need to be that formal and pedagogical. I like that word. I thought I'd put that out there. But I'm going to open it up to a lot of questions. And let me tell you a little bit about myself. I'm an attorney. I've been practicing for a long time. I've been practicing in Boise for 20 plus years, something like that. I do primarily work in the construction field, but not exclusively. I help people in a lot of disputes and issues that come up in the course of business relations, and that's primarily what I do. But in part, I've come to specialize in disputes that involve construction projects, and I also tend to specialize in issues that involve public contracts, be they construction contracts or other contracts that involve governmental entities. And guys, I know from having spoken at in front of this group many years ago that a number of members, and I don't know how many people we have on the internet, but a lot of folks here are in the design business, and others are in various other arenas that involve the mechanical field. But I'm just as a show of hands, how many folks would characterize themselves as in the design professional service rendering business? How many people would say that? Okay. And how many people would say, okay, I'm in the equipment business that involves, okay, so there's a lot of folks in the equipment business. How many people in the contracting business? Okay, so I see by and large, it looks like we got almost a fairly equal representation. And then there's some owners. There's probably one owner, a couple of other owners. Okay, so there's some owner representation as well. So I'm going to try and tailor my to try to reach your needs as they pertain to getting paid for the work that you do, and if the shoe fits on the other side, to ensure that you are doing what you can to not have to pay twice for services that are rendered if you're an owner or a contractor or someone who hires somebody to do work for you. Because those are the two ends of the spectrum. One is one party wants to get paid. Everybody wants to get paid, obviously, but nobody wants to pay more than they have to, and especially don't want to pay twice if they don't have to. So what we're going to talk about today, and again, I'm kind of open for a lot of questions. The two things that primarily pertain to getting paid for the work that you do, or the equipment and the materials that you provide, and that is in Idaho and as a lot of other states, we have a remedy for people who do work that involve construction projects, and that's the lien remedy. But for public works, we have no lien, because you can't lien public property because it belongs to the king, and the king is not going to let you take his property away. So those are the things we're going to talk about. But the other thing I think we need to visit about a little bit, and it's very relevant today, is for people who do work, who provide services to public entities. Let's talk a little bit about maybe the do's and don'ts of working with the government to and the issues that arise. Of course, there's a very timely decision that was rendered on Monday and was made public yesterday involving the state of Idaho and its procurement processes. And it's very interesting because I think that's the most widely reported decision that we've had in a long time on that topic. So I read it enough to be irresponsible and be able to talk about it without having studied it. So I'm happy to just stick my nose out where it doesn't belong and give you my opinions on it. But while you all think about the things that you may have in mind, I'll kind of go through what our history is and where your rights are and where they aren't in connection with getting paid for work that you do. Involves construction projects primarily in Idaho. So first we're going to talk about liens, because liens are something that I think probably everyone in the room has some familiarity, and it is the theory of the lien. It is the ability to have the lien that to do work with each other that have no relations with each other. You can embark upon a contract with a stranger that you don't know the credit history of, because you know at the end of the day that you have certain rights that permit you to at least start with a collateral that you can look to. So the Idaho State Constitution provides for a lien right. That lien right emanates from a constitution in 1890. It was modeled after, I think, another state's constitution. But it provides that, look, if you do work on real property, if you supply materials or labor, the legislature is compelled to give you a remedy. And the reason that it's important from a constitutional standpoint, okay, why is this guy talking about that? He's kind of wants to be a professor. There's a reason why the Constitution may someday be very relevant. It hasn't been a reported decision yet, but there's a clause that some of you may be familiar with. Clause in contracts that you receive that says, you agree with me that if you do this work and I don't get money from the owner, okay, that you don't have a right to be paid. And that's called a pay if paid clause. A pay when paid clause says, you agree with me that I will pay you when I get paid. There's a difference between the two clauses. One says, I will pay you when I get paid. Well, what that means, the courts have interpreted that to say, well, you have a right to get paid. You have a right to get paid, but the timing is going to be dependent upon when the owner makes the payment to you. The other clause says, you don't even have the right to ask for money until I get money on your behalf. Okay? Now, that's a pretty severe remedy. Imagine you do work, and you're expecting to get paid, and then the contractor says, the owner went bankrupt, and he's not paying me, and as a result, I have no contractual obligation to pay you. You can't sue me in contract. And the courts would say, that's a horrible clause, but it was express, and it was clear, and you agreed to it, and we're going to enforce it. That's an awful remedy. And why people don't like that remedy is because what it does is it results in you guys who do the work or supply the equipment or whatever in forfeiting the entitlement to be paid, which is the only reason you were in that game. So what happens in a couple of states, hasn't been reported in Idaho, what happened in a couple of states, why I mentioned the Constitution is because in states they say, well, look, that constitutes some kind of an inexplicit lien waiver, right? Because a lien waiver, you can waive your lien right, but you can't do it just kind of casually and not knowingly. But if you sign a document that says my right to be paid is contingent upon you getting money, and I waive that right, well, that constitutes a lien waiver. And the courts that have dealt with the issue say in cases where the right to lien is a fundamental right, well, then you can't enforce that clause because that clause is contrary to what the Constitution of Idaho provides, which says you have a right to a lien. Now, you could waive that right, too, because we're all big boys and girls, and we can do that. But if you don't, the court won't enforce the clause. So you do. The reason I mention it is that, well, that's pretty significant. You know, this Constitution will someday perhaps be put forward to the court and say, this pay if paid clause not enforceable because I didn't waive my lien right, and therefore you can't enforce that clause because if I have a lien right, then this clause can't be enforced against me. Otherwise, it is enforceable. It might be enforceable in the context of a public works contract. I can't think of a case that dealt with that. But of course, there's the Miller Act and the Little Miller Act. And the Miller Act is, we'll get to that, but that's how public jobs, right? And it says you can waive the Miller Act, but you can't waive it in advance, and you have to waive it when you do. It has to be in writing. So, okay, that's the. And our Little Miller Act doesn't quite say that, but there's a case that says we're going to interpret it like the Fed. So that's a long-winded way of saying I think it probably might not be enforceable in a public works setting either, but that's why I mentioned the Constitution. So now back to the other part. Okay, the Constitution says the legislature shall create these statutes, and the statutes shall be there for the purpose of helping people get paid for work that they do on construction projects that involve improvements to real property. So the legislature is doing what the Constitution compels it to do. The statutes are there to be construed in the favor of the party that rendered the services, that supplied the material. In our case, that was an engineer or a land surveyor. They're to be liberally construed in the favor of those people so that we can, A, effectuate the statute, and perhaps the policy is, oh, that we can have this. Upset the microphone. Okay, so who can file a lien? Now, our code section says that everybody who is hired by the owner or an agent of the owner to provide labor, etc., or to furnish materials. Now, or rent. That's a new statute, a new, relatively new provision. Equipment used in the construction of property shall have a right to lien. And in the 70s, the statute was amended to provide a lien right to engineers and land surveyors. And it said that engineers and land surveyors shall have a lien right. And it says that engineers and land surveyors, and in particular I'm going to focus on engineers, it says you're going to have a lien right for work that you do that's within your professional experience. There's a laundry list, and then there's a catch-all at the end that says if this is within your professional services that you're rendering, you're going to have a lien right for that. It also says, though, it follows up and says that is going to be in connection with an improvement to real property or the land. Okay? So the thing that hasn't been adjudicated, and it's an open question, is engineers are hired from time to time to provide drawings and specifications and calculations and things that might involve the improvement to real property. What if the project doesn't go forward? Does the engineer have a lien right? There's not a case that I can point to in Idaho that says one way or the other that the engineer shall or shall not have a lien right in the event that the engineer performed the work, but that there was never an improvement to the property. The language says in connection with an improvement to the property. And it strikes me that the court perhaps might interpret that to say that until there is an improvement, what you did wasn't in connection with an improvement. So your lien right doesn't exist until someone's turned a spade of dirt or improved the land some way. Surveyors, clearly, the language says that if you're going to draw new boundaries, that's a lienable event. Okay? Now, surveyors typically have to go out and they have to put a stake in the ground, or maybe if they're going to draw a new boundary, or at least they have to recite the old stake. Hard to say, but it would appear that that is approved for surveyors. I can't tell you whether engineers have the same remedy. here's one concept that you need to keep in the back of your mind, because engineers, architects, contractors even, get hired before the project goes forward. And they get hired for the purposes of determining whether it's feasible or not. Okay? So if you're in the business of providing engineering services, say civil engineering services, and you're trying to ascertain whether or not ground for a certain client is going to be feasible for their intended use, at the time that you were hired, you were not hired by an owner of the property. You were hired by someone who was thinking about buying the property, because that's why they hired you. So I would submit that because the statute indicates that you have to have a right that derives from the owner, that right that you got didn't go back to the day that you were hired until that party became the owner. And it makes sense, right? If I go out and hire an engineer or someone to help me do a feasibility study and they end up not acquiring an interest in the property, I certainly, as a prospective seller, wouldn't want to have liens get established on my property because someone was doing some work that I didn't authorize. On the flip side of the coin is, when you do work, I mean, this is where it gets complicated, because you, as a early on design professional or contractor, someone who's going to provide some service, might be retained by Company A. Company A has their developer, but when they buy that property, Company A is not going to buy the property. Property is going to be bought by an LLC that they have developed for that purpose of buying and acquiring that property. Now, who's your contract with? Well, my contract was with Company A. So is Company A the owner or the agent of the owner? Well, they weren't the agent of the owner at the time that you started to do the work, because the owner didn't exist at that time. The owner was an LLC that they formed when they decided to acquire the property. So it gets complicated. Ultimately, they become the agent of the owner at the day that that owner acquires the property, because more than likely, even though your contract with Company A, there's a relationship between the LLC and A, so that A is the agent. Okay, it gets complicated, but then that's why my phone rings, right? Because people go, well, this is goofy, and I don't know where to start. But it's easier for contractors. It's easier for material suppliers. It's easier for people who supply equipment, rent things, because the project's kind of already started in some way, shape, or form. The design's done. Things are getting ready. Spades of dirt are being turned, and the owner is known. Or doesn't need to be known necessarily, but you're working for an agent, the general contractor, or someone who the owner has hired to do this work. It gets a little more complicated when you talk about whether you're doing work for a tenant. Tenants can be big. Tenants can be small. Obviously, we think of tenants as, the common tenant that everyone can have in their mind is when you go to a shopping mall or you go to some store and you go, well, there's a store and the storefront includes, I imagine this building leases space to that tenant who operates that store. So you do work for that tenant. You have a lien right, but it may only be for the interest that the tenant has in the property, not the whole building, right? Because the building's owned by somebody else. I guess I mention that because there are other circumstances in which the tenant has a ground lease, and they're acquiring the entirety of the ground, and they're going to build upon it, and they're going to build something, and then you're going to be foreclosing an interest in what? On the ground lease. It gets a little complicated, but it certainly can be done. You can foreclose an interest on a ground lease. The difficulty is ground leases are subject to a lot of terms and conditions with the lessor. One of the things is to probably make an annual payment. Well, if the ground lease goes into default, you do all this work, you build the Hoku plant, right? City of Pocatello is the plant to Hoku. Hoku built this huge thing on it, and then at the end of the day, Hoku didn't ever own it. They had a ground lease. Well, there was a way to get around that, but that's complicated, and you need to know that going in if you're going to be you need to think about it going in. Sometimes these thoughts really come to mind after the fact, because it's kind of unusual, and it certainly is something that you need to know. Well, is my competitor worried about this? Should I worry about that? Those are the things that make it complicated. But I point it out because there's one other aspect about leasing, and I'm jumping around a little bit, but you need to know that when you do work for leased premises, don't think that you don't have a right on the entirety of the building or the entirety of the real property. The reason is it's not uncommon for people to compel the tenant to build the thing that is under construction. Landlords don't like, if they're in the business of trying to develop a shopping center. Well, I don't want to lease a pad that sits in the front of my shopping center to somebody who's never going to build anything on it, because I got an eyesore. Every time people drive in, there's this patch of burnt grass that no one's building on. I want to enter into a lease with the guy who's going to build the gas station, but I need to compel him to build and operate the gas station, because that's important to me. I need these stores not to be vacant, because that doesn't do much for me attracting people. So what I do is I put in my lease, you shall build and operate this thing. And I think what that does is it gives the claimant, the parties like you who are doing the work, to say, well, wait a minute, I can get to this guy's interest because he made the tenant, the agent, he made this guy build this thing, so therefore I get to say, and I don't just get to get the tenant's interest, I get to get the landlord's interest. So don't feel like you've hit a dead end when you realize you did this work and now this thing's in trouble and you didn't get paid, and all the guy has an interest in the store at the village because, you know, gosh, it just didn't work out. The company went belly up. The landlord may have compelled that build out, and if so, I think you can probably get to the landlord's interest. At least I wouldn't give up at the outset. And so keep that in mind. I digressed a lot, but I did, okay, one of the things here is that the purpose for the lien law is for people to know that if I'm supplying things to a project, that I have a right to be paid from the improvement that I did if I don't get paid under my contract. On the other hand, and so in effect, I'm looking to the project as security for my ability to get paid. What does the last part say? It says, well, if I'm a supplier and I'm supplying to a guy who buys stuff from me, I'm not looking to any credit past him. I'm saying, you come into my shop, I sell you this thing on credit, you take it away, I don't know, maybe you put it somewhere. But I didn't sell it to you based upon the fact that it was going into the XYZ project. Because I just, you picked up some stuff and I sold it to you. So a supplier to a supplier, right, that won't get you a lien right. You supplied somebody to somebody who's not installing anything, he's reselling it. Well, the court says we're going to cut you off. You're not looking to the project. Now, if you're a supplier and a contractor, subcontractor comes and buys stuff from you and it goes to a project site, that doesn't mean that you don't have a lien right. What it means is you better find a way to get your trail of your thing to that project site so that you can say, I sold my thing and it went to that project and it's there right now and I didn't get paid for it. Hard to do when somebody just comes to the shop at the counter, they buy something, maybe even expensive something, and they take it away on their equipment, their truck. Easier to do if you deliver it, you know where it went. You can say, that's my thing, I delivered it, I didn't get paid for it, I'm going to lien the job for it. That's, yeah.
It seems like now there are a lot of contractors that
well, it would take your right away. If you had a supplier who supplied to you, and the supplier wouldn't have if they didn't execute a release as well, they wouldn't have lost their lien right. You would have lost yours, but the supplier can still say, well, no, I didn't get paid, and I didn't sign anything, and I'm going to, yeah. Now, and the other thing that comes up, and I'm glad you pointed out, this is pretty common paper trade. I want a pay application, and I want you to provide with that pay application a release of lien. And the release of lien typically says, this is contingent upon me paying you. If I give you this check and this check clears, then this constitutes a lien release. And then next month, they say, okay, last month I gave you the check and you gave me the lien release, and now I want an unconditional lien release, not something that was conditional when I gave you the check, but now I know the check's cleared. I want an unconditional lien release for last month's work and a conditional lien release for this month's work, okay? So now we're going to go through this process again. The thing that's somewhat troublesome that is that as far as the owner is concerned, the owner's been able to say, I get these lien releases and I rely upon the lien release. And I got a lien release from Halbert's Lumber. And Halbert's Lumber said in their lien release that through the 15th of July, they released their lien rights. And then the general contractor went bankrupt on the 1st of August. And Halbert's said, well, I did. I gave you a lien release, but I gave you a lien release for the stuff that I had invoiced. See, I hadn't invoiced for the things that I delivered on the 12th of July. I just delivered them, but I hadn't invoiced for them yet. So I couldn't ask me for a lien release because we didn't know what the amount was going to be. I hadn't even sent you a bill. And the court said, you know, this says that the release is effective through the 15th of July. And Mr. Halbert, I'm so sorry that you didn't put it in your bill because we're going to take your lien right away. And they enforce it. And that's worrisome because people, it's not uncommon for material suppliers to not have their invoices in the system at the time that the deliveries are made. And that's a worrisome part. But I bring it up because you need to know that these things are effective and they have teeth in them. And even if it's conditional, if it's a conditional or unconditional lien release simply says, I've been paid, there's no question. It's not conditioned upon me, this check being made. Conditional one works, helpful because everyone knows, oh, I get it. If this guy's check clears, I get my liens free. All I have to do in court is prove that the check cleared, and then that's an effective lien release. Unconditional says, there's no question, there's no conditions, everything is done. Yeah?
Is it unwise or not right for someone to say, I can't get your check out, you sign an unconditional lien release?
Yeah, that's risky. You know, I mean, but the thing is, it's funny you mention that because it's not, in the last, I don't know, few years anyway, it appears that more and more times people have said that's what we're being told, is that give me the unconditional or you won't get your money, especially on the final payment. They want this unconditional in advance. But it's troublesome because it's not conditioned upon the receipt of money, and it says so typically right on its face that if you haven't been paid, it doesn't make a difference. Now, the owner it relies upon it, and so it's the owner's title. Now, I would submit that if the owner is asking that of the general contractor, maybe there's a claim for fraud, right? But again, it's hard to say you rely upon a document that says on its face, don't rely upon this if you haven't been paid, you know, this waives your rights. So you're going to say, well, how would you reasonably have relied upon this owner's promise that's contrary to what you signed? That's a hiccup. You know, and and here's some funny case law on things like that. Courts are put in tough positions sometimes because of bad facts. And courts nevertheless more often than not, enforce the law because it makes sense, even though this one poor schmuck is going to really get hurt. In that regard, talk about the unconditional lien release and the effectiveness of it. It was a case that involved an owner who sought out an unlicensed contractor. Not because he was unlicensed, I don't think, but he sought out this unlicensed contractor because this contractor had skill that no one else in the area had. And I said, I need you to build this thing because I know you can build this thing because you have experience. But, and he says, contractor says, I don't have a license to work in your state. The owner says, don't worry about the license. Just go ahead and do the work. Because it was a very unique project. And the owner brought this guy from out of state, did the work. Dispute arose toward the end of the job. Contractor said, I'm entitled to additional money because I did extra work beyond what my scope of my contract was, and you haven't paid me for it. Owner says, I'm not going to pay you. Go pound sand. You're an unlicensed contractor. Well, you knew I was unlicensed. You told me not to worry about it. Court, what do? Law says unlicensed contractors don't have a right to be paid. Contractor says, I agree. I'm not suing them on contract. I'm not suing the owner for mechanics lien. I'm suing the owner for fraud. Court says, it says you have to have a license and you can't bring an action for anything without the license. You lose $290,000 you walk away from. I bring it up because you go, well, they wouldn't do that to me, right? Well, so yeah, you have to worry about these things, and so it's a little bit nervous right now. Go ahead.
Let's go back to like the case that we talked about. This past one of the villages that you got a developer who wants to put something on a pad. He hired an architect. The architect then hired an engineer. I don't know if it's a contractual relationship between developer, or whatever.
Yeah.
We do complete the design. Not a shovel is, like you said, no dirt turn at all. The design's complete.
Yeah.
Like a lot of developers, they're flaky, they don't have the money, whatever the project is. That development company is now one individual LLC. They do that one project.
Yeah.
Yeah.
I think it comes down to what the phrase "in connection with" means in 45501. 45501 says you have lien rights. They stem from a project in connection with an improvement. There's no decision that says the improvement has to have been commenced. But I think that it's a tough one. I would say I would put a lien on the property, but well, that's right. And here's the second. And the reason is, if you think back a little bit, okay, if there's an improvement to real property, even spades of dirt that are turned, someone who is out in the world who decides that they want to buy that pad can say, okay, I'm going to buy this pad, and then they say, yeah, here's for sale. It's like somebody turned some spades of dirt over here recently. That puts me on notice that maybe there's someone out there who's been doing some work on this pad that happens to be near a shopping center that has, kind of puts you on inquiry notice that there may be something to worry about. And then you ask yourself, well, okay, from a commerce standpoint, how does the world work? Well, it works because people get title insurance, right? Title insurers need to know, is there anyone out there working on the job that I need to worry about? Do I need to get subordination from? Do I need to get more collateral from somebody, charge a higher premium? They look to spades of dirt, some improvement to tip them off that on the day they were about to issue this policy, there is likely potential for a lien. Engineer does its work, does a lot of work, doesn't get paid, no improvement. Court may say that in connection with language means that until the improvement commences, there's no lien to it. It doesn't attach yet. It attaches on it. Now that, yeah.
One of the things that the developer does say he's going to go on for 6 months. But yeah, we're working on financing. Don't worry about it. 6 months go by, no one gets paid, and now your lien rights are 55.
Yeah, because I think, you know, again, it comes down to that work within which you did 90 days. Now,
what happens if I go back to my plan and say, oh shit, I missed the change on the plan. Now, if I work, is that something that can? Hey, I want to get paid.
it's well, I would say.
Is that enough to then say, yeah, the 90 days kicks in from that starting point there forward? What would?
Yeah, I think
I completed the plan 6, 7 months ago, but now it's like, now we know it's not going through. Can I just then go ahead and say, oh, I missed a couple things on that. I really final check, and yeah, my lien right now start over from.
I'll give you an analogy. There's no case law that I can point to which is spot on, okay, but there's some analogous cases that are going to be helpful. And they talk about, okay, when do my lien rights as a contractor expire? And a contractor probably can't look to the last time that he or she corrected work as a time in which their lien rights were last there. If this thing needed to be done, if I needed to put the switch plate on that and I didn't, conceivably that's work that has to be done. And if I don't do it, I haven't completed my job. On the other hand, if I put the switch plate on, but it was the wrong color, or it wasn't on so well, or it broke after I put it on, then what I'm doing is correcting things that probably the court would say, no, that you did the work. You came back and you did some corrective work. I'm not going to say that that's sufficient. Secondly, trivial work won't count, right? It can't be, in the scheme of things, a switch plate. There's case law that you can point to where in a motel contract, 4 soap dishes were sufficient work to be looked at for the timing of the 90 days. In your circumstance, I guess the question would be twofold. One, is this work I had to do? 2, certainly if it's work I was instructed to do, I don't think you have a problem with that. Is it work I had to do? Possibly. You may get somewhere. Is it work that is going to appear to be transparent? That this work was done for the purposes of getting you within the 90 days. It's not work that was done because you felt an obligation to complete it because it was within your contract to do so. That would be where I would be.
If it's instructed, it needs to be instructed by someone in writing before you instructed that.
No, it just needs to be instructed. It would certainly be helpful if you got an email or writing or something like that, but it doesn't have to be, and it doesn't. And the authority just needs to be the person who has got the authority by virtue of being the person you always dealt with. They were the agent. The owner appointed them the agent. But back to your point. Remember, in the previous slide, we're going to try and construe this liberally in favor of the people who do the work, and we're going to make sure that, because that's the way the thing goes around. Don't make sure that the people who do the work get a fair shot at getting paid, provided they go through some hoops. Pretty soon, this thing isn't going to work anymore. People just are going to say, well, okay, I'm going to need some other security. I'm going to need to go to get a letter of credit from the bank because I'm not going to show up and do, well, that's going to goof things up. We don't want that to happen. But I think I would start with an aggressive approach and then be mindful of the fact that I'm out in the fringes.
So we talked a little bit about the Remedies.
Yeah.
And you have the opposite of that. You say, I want a filing. There's cases where confusing things that, well, you assign that.
Can you assign a lien, like if you did work but you wanted to see if someone else was?
Well, kind of the opposite of the retail lien, the property, but in the circumstances where it's not clear, so if I do this work, it's not clear, I would have it.
No.
Have
boy, I think if you got a consent by the owner that, yeah, and that gets to another point. If the owner consents that your work constitutes something for which you have a lien, I think you're a long way ahead. Now, here's the dilemma, right? I mean, we have this crazy part of the law that says you have 90 days to record your lien. Okay, 90 days to record your lien after you do your last work. Then then you have 6 months to file a lawsuit to enforce your lien. So your lien, first I record it, then I can wait 6 months and I have to file a lawsuit, or it goes away again. There's a part of the statute that says, unless I get an endorsement of my lien from the owner extending the time upon which I can enforce my lien, file my foreclosure suit. Well, the endorsement comes up very rarely, but it comes up in the context of the owner. I mean, you've been there, right? The owner says, well, you know, I've just got this money is just about to come through the bank, the lender, whoever it is, about to get it. I just need some more time. Would you give me the endorsement? You know, I'm going to give you the thing, and you'll have a lien right. It won't go away. Okay. Problem arises when a third party intervenes and says, well, wait a minute, that was good for you, right, Mr. Owner, but I have a lien right that I didn't give this guy an extension, and I want to say that this extension may be bound against the owner, but you didn't bind me. And for example, I'm a lender, right, and you have priority over me, okay, and I know you have priority over me. And then I have a loan on the property, but you started first, so I know that when push comes to shove, you're going to be able to say, look, I'm going to foreclose your interest too. You go and get an endorsement from the owner, and the lender says, well, wait a minute, I'm not going to stick around forever while you guys, you know, put me in jeopardy. I'm going to say that I have priority now because I never signed on to your endorsement. I bring that up because you want to talk about, hey, can I get the owner to agree in advance? Yeah, you can, and that's great, but just remember, it may go only as far as the owner. It may not go further than that. So, yeah.
There's a project scheduled for supposedly for final fall. There's an American fall. It's going to change fertilizer into or natural gas into fertilizer. It's supposedly a $3 billion project. The last I heard, URS is going to do site work, but they have been trying to do the general work. It's not built a project like this in 20 years, and the contract is on a completed operable system. So Bechtel may build it, but their payments is depending on what the notice is. The system works, and it doesn't work well. They don't meet the parameters of the contract, they don't get paid. Now, if the subcontractor or supplier supplies good, would you get legal advice on your purchase order of the contract?
I would if it looks like they're going to try and have you sign up to the same thing they signed up to. If it looks like your contract is going to be intertwined with theirs, then yeah, you're going to want to make sure that you are really on board for this long-term deal where your right to be paid is going to be dependent upon how well they do, right? Okay, if I'm really on board for that, then I need to know that. And again, it gets back to what I said earlier with the constitutional right to the lien. Is this an inexplicit waiver of my lien right? You know, I think that's going to potentially come up. On the other hand, if I was Mr. Bechtel, well, I want people to work on my project. Now, at some level, they're just not going to show up if I start putting crazy contracts in front of them, right? So there's going to be, at the higher level, I bet Mr. Bechtel, if he goes forward with this contract, is going to want to try and get everybody that he can to sign on board to where he signed on board to. At the lower level, you know, the guy who's going to really, you know, put the grading equipment out there, who's going to pour the concrete foundation, that guy's probably not going to sign up. He's going to say, look, I'm not here for that. I'm not here for how this thing operates. I will pour your foundation, I'll put the rebar in, but I'm not going to sign up for the other stuff. So that's what I would say. If it looks squirrely, then yeah, I would definitely start to get help.
On a project that big, eventually it's going to have to work. But somebody's going to have to wait 1 or 2 years or 3 years before they work all of us out in order to get paid. That's a long, long way.
Yeah, and you need to know, I mean, honestly, I think that the thing is knowing going in as opposed to learning after the fact. You know, and you know, the sophisticated subcontractors are going to ask that question of themselves and ask it of Bechtel. The unsophisticated subcontractors may just do what folks do, which is they sign a document that's put in front of them. They don't really question it much, and they know that what the price was. They expect to get paid for the work that they do. They didn't look too much at the details. I mean, I can tell you that happens a lot. You know what happens a lot. Folks take contracts from people that they've done business before. They sign them. They move on because they've got a history of getting paid for work that they do, and it's not until all of a sudden this thing gets squirrely that they're like, well, we really need to look at this thing that I signed. You know, that's kind of the way that the world works sometimes.